When you see Blake Lively as Lily Bloom for the first time, your reaction is?
I will never picture anyone else. Like, she is absolutely perfect for the role. When he told me that she was thinking about taking it, I refused to get excited. I was like, oh, what if it doesn't happen? Because I was so excited that that was a possibility. Man, she knocked it out of the park. Yeah. And their chemistry together is insane.
Hey besties, welcome back to my channel. Judge Lyman just issued a scathing order against Blake Lively, and she is, woo, if this is an indication of what's to come with any motions on judgment on the pleadings, her entire case might be at risk of being thrown out because the judge just dismissed Jed Wallace entirely from the case. No more options to amend the case, no more nothing. He has stated that New York court has no jurisdiction over Jed Wallace. Nada. Zilch. Zero. The order came down this afternoon, and the judge has stated that as far as the Southern District of New York goes, the case is dismissed with prejudice. But if she wants to refile it elsewhere in an area that has jurisdiction over Wallace, she can. Although the current lawsuit that was dismissed heavily relies on all of these different theories of jurisdiction of why Jed should be a part of this case. And so therefore, she'll have to reformulate the entire lawsuit. So one aspect in here is that he does address a couple issues related to the FEHA claims, the ones for workplace retaliation, along with the harassment and retaliation. And so essentially, what the judge has stated is that Blake's FEHA claims fail against Jed Wallace under a conspiracy of jurisdiction because it's defamation repackaged as workplace discrimination because they sound in defamation. So he says in the SAC, Lively identifies three separate bases for personal jurisdiction over the Wallace defendants: conspiracy jurisdiction under CPLR 302A2 on the theory that Wallace defendants, co-conspirators, committed tortious acts within New York in furtherance of a conspiracy and that those contacts can be imputed to the Wallace defendants. Personal jurisdiction under another theory that the Wallace defendants committed an act outside New York causing injury to a person and property within the state, and that they expected or reasonably should have expected the act to have consequences in New York, and that they derive substantial revenue from interstate commerce, and conspiracy jurisdiction on the theory that the Wallace defendants, co-conspirators, transacted business within New York and that those contacts can be imputed to the Wallace defendants. He says that she has failed to establish jurisdiction under any of them. So he's gone. The New York court can't do any of it. And I think it's telling because he seems to poke holes at what she claims are the retaliation and what she suggests are employment retaliation, when in truth it sounds more like defamation. And this ruling could theoretically impact anything else as it relates to the FEHA claims for any of the other parties. So here is what he said. Here, the Wallace defendants argue that Lively's two causes of action against them, false slight invasion of privacy and abetting harassment and retaliation, both sound in defamation and thus are exempted from the conspiratorial law for jurisdiction. The court agrees that the essence of these claims is injury to reputation, that the claims therefore sound in defamation, and that personal jurisdiction accordingly may not be predicated under either section of this law. This is wild. So he is stating that her claims related to the harassment and retaliation sound like a reputational injury, not a workplace injury, but a reputational injury. That's an issue that impacts her entire lawsuit, not just Wallace's case, but the entire lawsuit. He points out that not only do the allegations specifically and repeatedly focus on her reputation, but they also refer more generally to public perception and sentiment and publicity. The complaint directly ties the alleged economic harms to reputational injuries. Lively identifies no harms associated with this cause of action that are divorced from reputational injury. Court therefore has little difficulty concluding that this is a claim that sounds in defamation. So, under the law in New York, you can't take and repackage claims that sound in defamation. So, you can sue for defamation, but then you can't add a bunch of other different claims that are essentially just defamation repackaged in a different form. In this case, he's saying that what she has done is repackaged the harassment and retaliation, the aiding and abetting, as defamation. It really is defamation. And what she's also saying is that the invasion of privacy is also effectively being repackaged, but it's effectively defamation. And that the only injuries she actually tells the court that happened are reputational. And this is telling because reputational injury is not a workplace adverse impact once the workplace relationship is over. He says that all of her arguments to try to say that this isn't really a defamation lawsuit are unpersuasive to him. He says that she asserts that because she has not sought to premise her false light claims on any alleged defamatory statements, her claim is genuinely not duplicative of an unpled defamation claim. But as previously explained, a plaintiff cannot avoid the defamation bar by the contrivance of not identifying any specific statements alleged to be defamatory or by not challenging the truth of the injury statement. Whether a claim sounds in defamation turns on the nature of the alleged injury, not on the form of which a message is sent or whether the plaintiff has identified any specific defamatory assertions. In concluding, the plaintiff's claims sounded in defamation. The New York Court of Appeals explained that what mattered was that the harm asserted, substantiated by the plaintiff, injury to his reputation, was precisely the same as caused by defamation. Now, what he says about the FEHA claims is also interesting. And here he says, although FEHA retaliation claims undoubtedly often have little to do with defamation, this is an unusual case in which the retaliatory acts identified relate exclusively to efforts to damage an individual's reputation and credibility. Indeed, the only alleged adverse employment action that the complaint specifically identifies is the launching of a coordinated campaign to cast her in a false light during the publicity and promotion of the film thereafter. Lively's FEHA claims thus fall back on allegations regarding efforts to cast her in a false light. Allegations which the court has already explained sound in defamation. Essentially, what he's doing is he's saying that this entire smear campaign that she is proposing as a thing, right, is not a workplace issue. It sounds like defamation. It sounds like it damaged her reputation. She's claiming that it caused business injuries. She's not claiming that it impacted work, right? So what this could mean for Wayfarer is that when it comes to summary judgment, they can use this same argument and say that the court has found that these claims sound in defamation and thus do not meet the standard of a workplace injury. And they could seek to have it dismissed under the law. This is what he says on page 21. The fairest reading of these allegations and the SAC more generally is that the entire injury complained of by plaintiff flows from the effect on her reputation. Indeed, to the extent that Lively identifies harms other than purely reputational ones, she effectively concedes that those injuries flow from the effects on her reputation. Take, for instance, her alleged business and professional harms. She asserts that given the ongoing nature of the campaign and the associated negative sentiment, she did not believe that she could proceed with public appearances or events, canceled a critical target corporate event for her hair care company, as well as an invitation to host the premiere episode of the 50th anniversary season of Saturday Night Live. She has also canceled appearances on behalf of her other businesses for the same reasons. Furthermore, the SAC expressly identifies the sudden and unexpected negative media campaign launched against her as a case of depressed retail sales for her hair care line products, noting that the Lively's hair care line were caught up in the crosshairs, if not entirely by the retaliatory campaign initiated by defendants. It is well established that lost business or professional opportunities flow from generalized reputational harms, give rise to a suit for defamation. So, what this could mean for everyone, not just Mr. Wallace, is because when they put together their summary judgment, again, they can say that she is trying to allege that reputational harm is an adverse workplace event, right? It has to meet the legal threshold of what an adverse workplace issue would be. And reputational is not equal to a workplace injury. So it has to be comparable to a protected activity. The adverse employment action would have to be firing, demotion, discipline, or tangible workplace harm, and a causal connection between the protected activity and the action. He pointed out in this filing that the things that were her claims for workplace were loss of professional standing, damage to her reputation, accumulation, and interference with future income. But that's not an employment action. They're public relations consequences. So they sound more like defamation than they do discrimination. And so this could impact all of her FEHA claims as it relates to the smear campaign. And if you take away the smear campaign, then the other FEHA claims of sexual harassment are actually time barred under federal law because it's 300 days from the last reported incidents, which she claims was in May of 23. It's really going to be fatal across the entire case. And I think that he issued this ruling a week ahead of when these summary judgments are due so that this can be weaved into whatever arguments that they make to him for why it should be dismissed on summary of judgment. Because summary judgment is all about saying that things need to be removed based on the law. And that there's no dispute about the facts of the case. And so here what they can say is, well, you already ruled that the FEHA claims are reputational, they sound like defamation, so these must be dismissed. It doesn't even have to tap into the extraterritorial aspect. It's pretty good for them. This gives this will help Wayfarer moving forward. He says that she similarly ties her emotional injuries to the smear campaign, negative publicity, and corresponding online attacks. Her case therefore resembles those in which courts have found that claims for intentional and negligent infliction of emotional distress sound in defamation. So any time that she notes that she was getting placed in a false light, that she was shamed, that her reputation was damaged under New York law, that's defamation. It is not FEHA. It is not a retaliation campaign. It is not a discrimination law. It is not a adverse workplace event. It is defamation. And then she says, to the extent that Lively identifies harm stemming from their lawsuit against her, which she asserts was retaliatory and frivolous, the harms that she has pleaded are also ultimately reputational. This suggests to me that, again, he may not take seriously her claims of the 47.1 for the fees because it's reputational issues, not workplace discrimination. It is not an issue where she's being harmed because of that. And he's going off New York law more than he's going off California law. So this is, again, another issue for her. Listen to this. Lively's responses regarding her aiding and abetting claims, like those made in connection with her false light claims, missed the mark. She contends that aiding and abetting involved more than boosting negative narratives about Miss Lively on social media. It also involved providing advice and counsel to Wayfarer parties and strategizing with them on conduct of their retaliation campaign. Activities that do not even arguably sound in defamation, but are core aiding and abetting conduct, irrespective of the form that the retaliation took. That's what her arguments, okay? Even if he did provide advice, counsel, or to her, rather than simply boosting negative content online, the question remains advice, counsel, and strategic assistance regarding what? The only answer that question that Lively's filings and complaint reasonably suggest is advice regarding publicity, public relations, and shaping of public perception. Lively's response also falters by focusing exclusively on the activities in question rather than the nature of the injury. As the court has already indicated, unlike most torts, defamation is defined in terms of injury, damage to reputation, and not in terms of manner in which the injury is accomplished. She has failed to establish a personal jurisdiction on Wallace. The conclusion is especially appropriate given that, unlike many other cases at the motion to dismiss stage, there has been extensive discovery in this case to date. Lively has obtained discovery shedding light on when the Wallace defendants joined the conspiracy and their knowledge. So she provided that evidence, and he said it wasn't good enough. So he also doesn't buy that, they hired Wallace when they were in New York, that certain events around the film took place in New York, and that in and of itself would have jurisdiction over him. Um, she tried to say that even publishing the website that posted the documents of the lawsuit were part of jurisdiction, which he said were not. But I think what is most important is that he's really treating these things as defamation, and he's looking at this from a speech issue. Okay. So he is not looking at this as it pertains to discrimination. He is looking at this as a speech issue. And he makes this clear on page 39. He says, exercising personal jurisdiction over the Wallace defendants based on such a broad conception of agency and conspiracy would be inconsistent with free speech considerations and New York court's instruction to apply narrowly in defamation cases. Consider a hypothetical scenario in which several individuals loosely organize themselves online for purpose of promoting an issue of public importance, say to bring public and government attention to an alleged defect in a popular consumer product. The individuals are scattered across the country, save for one location in New York, and they research, write, and publish posts in their respective states that are accessible online in New York. It is clear that the individual located in New York may be subject to a suit in New York on claims of defamation on product disparagement, and that the out-of-state individuals are protected from being held liable under this, law. On Lively's expansive theory, those same out-of-state individuals could be sued in New York so long as a plaintiff plausibly alleged that they are aware of the New York-based members' purposeful activities in New York in furtherance of their shared end, even if they had no direction or control over the activity, and even if it was not necessarily to their own out-of-state activities. Applying this would effectively permit an end around the statutory defamation exception, opening New York courts up to a vast array of out-of-state defendants. So he's not going to apply it to Wallace based on her theory because it could impact the entire state based on his ruling. It could impact the speech. It could cause out-of-state defendants to have to go to New York court over statements they had nothing to do with. And so all the things that she was trying to do, like saying Jen Abel was there, Kate and Koslow were there, Melissa Nathan was there, Jen Abel, Wayfarer, blah, blah, blah. None of that matters because Wallace had nothing to do with any of those things. So at the end, he says, in light of the court's disposition of the motion to dismiss for lack of personal jurisdiction, the court does not address his arguments for failure to state a claim for relief or venue should be transferred. He says that it's dismissed for lack of personal jurisdiction and it's dismissed as to the defendants without prejudice to refiling in a court that has jurisdiction. So if she wants to take this somewhere, it cannot be in New York. She failed after a second attempt to link him there. She was unable to convince a judge that other people's activities were the responsibility of Jed. He doesn't really, I think this is a broader of the mindset of him in terms of whether or not he's actually taking seriously this idea that bad publicity is somehow a negative work consequence. And because New York laws are really tight around not repackaging claims that sound in defamation, he would be able to use that for any of these other claims that have the same impact that caused reputational harm. And it's devastating for Blake Lively because he even addresses that her claims that a frivolous lawsuit damaged her reputation also sounds in defamation. But he doesn't seem convinced that the lawsuit was frivolous. It honestly sounds like her lawsuit is frivolous. And for her to refile in another jurisdiction, she has to take out all that stuff that's in this lawsuit about New York, which is like literally dozens of pages. She has to extract everything that's not related to Jed Wallace and base it solely on Jed Wallace, not to so as not to confuse the court. And the state of Texas has much different rules in terms of what it allows you to bring forward for a lawsuit. She has to have reasonable basis and reasonable evidence to prove that he did these things and that it was actually what she said it was. And if she doesn't, she can actually get sanctioned in Texas and she could be penalized. So this same lawsuit, if she were to have brought it to Texas to begin with, could have been tossed based on that. Because even if what she says Jed Wallace did is anything, it doesn't sound like anything other than reputational. And she can't link any one thing directly to Wallace. She never had a case against him. She only had a theory, and that theory was based on the premise that this is what it was. And it just proves that this entire lawsuit, at least in my opinion, is a repackaged version of a defamation case, and that ultimately it was all about the bad PR and her trying to blame someone else for the bad PR. It had nothing to do with sexual harassment. That's just my opinion. So long story short, this is devastating for her, and it probably explains why she's doing all these sanctions motions, because she's trying to win the narrative, trying to get ahead of these bad headlines, because she's going to be on the receiving end of damaging headlines for the next several months as her case is chipped away piece by piece. And with Wallace out now as a defendant, her smear campaign, like entire premise of it, really falls apart because he's supposed to be the orchestrator of it. And now he's no longer a defendant. It's pretty bad for her, pretty bad. So what are your thoughts? Tell me in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.